Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mr. Hill, good morning.
Morning, Your Honor.
You've got what file?
I'm here on 052 Midland Credit versus Carolyn Simmons.
I don't have Ms. Simmons as of yet. Put you back in the waiting room.
Okay, thank you.
Morning, Judge.
Good morning. What file brings you here today?
Well, it's funny you should ask. I am here on file number 221-97082. And that's LBNB funding versus Sylvia Moore, and I have a signed consent judgment in my hand.
Well, I don't have that file on my docket because we were told that there was a consent. So let's put
Well, that's just fine, Judge. So I have the signed consent judgment. I will not be able to file this today, but I will be able to file this down in the clerk's office tomorrow.
That's good enough for government work. Thank you, Mr. Russo.
Thank you, Judge.
Be safe. Ms. Fraser, good morning.
Good morning, Your Honor.
I can't hear you.
Good morning, Your Honor.
I don't have your opponent as of yet, so I'll put you back in the waiting room.
If I may, Your Honor, we actually filed a notice of settlement that was sent into the court last week. I don't see that appearing on the docket. When we did check the docket, we saw that notices for this hearing had been mailed to the parties, but I didn't receive it. And I checked with the plaintiff yesterday and he didn't receive it either. So I don't anticipate that he will be appearing.
Let's call your case and you can put all this on the record.
Okay.
On your way. We are on the record calling file number 22243-370. Leonard Thomas Humes versus Experian Information, date and time for pretrial. Your appearance, please.
Tamara Fraser appearing on behalf of Experian Information Solutions Incorporated.
Bar number.
51997.
Counsel, you were saying the case has been resolved?
Yes, Your Honor. Mr. Humes and I resolved this case about 2 weeks ago and submitted a notice of settlement to the court last week, which doesn't appear to have been docketed as of yet. When I reviewed the docket to see if the notice was there, we realized that there had been this hearing set for today. Even though the docket indicated that notices of the hearing with the Zoom instructions had been mailed out, I did not receive them, and I checked with Mr. Humes yesterday, and he did not receive them either. So I don't anticipate that he will be appearing this morning. I did email him and tell him that I would attempt to appear in an effort to inform the court of the status.
All right, so what you're telling me is that this case has been settled.
It has, Your Honor, and I would request perhaps 30 days for us to get our dismissal paperwork into the court.
All right, what I'll do is I will adjourn this file to February 9th, 2023 at 10 o'clock in the morning. Hopefully your paperwork will arrive before that time. We'll send out notice of that today.
Okay, Your Honor, I'm wondering if you might agree to just a bit more time. If we mail this into the court, I'm concerned that the dismissal order might not get docketed promptly as the notice of settlement didn't.
Well, when did you mail your notice of settlement?
January 3rd.
Okay, well, if everything is done, you should be done in 30 days. Because ordinarily what I do on these cases, when counsel tells me the case is settled, I dismiss it without prejudice pending receipt of your closing paperwork. So I'll give you the 30 days and we'll figure out, that should be enough time.
Okay, all right, well.
You might have a holiday backup as part of your problem.
It very well may be. Okay, well, we will do our best to get this into the court and on the docket by the 9th of February.
All right, we'll send you out a notice today. Thank you.
Thank you.
Be safe.
Let's see.
We are on the record. This is file number 22190052. The file is entitled Midland Credit Management versus Caroline Simmons. This matter is set for pretrial today at 10 o'clock. It's now 10:30. Should I have your appearance?
Good morning, Your Honor. William Hill, P 28608, appearing as coverage counsel today for Midland Credit.
All right. Oh, Mr. Hill, I'm sorry. I'm looking at the notice here. And attorney Diane Exagoras filed an answer on behalf of the defendant here. But for some reason or other, the notice of today's pretrial was sent to the defendant rather than her counsel. I have to set this matter for another date.
Okay,
Our notice was defective. That day will be February 9th at 10 o'clock.
February 9th and there is an attorney filing an appearance. We don't show that in our file.
Filed an answer.
Okay,
Diane, you got a pencil?
yes, sir.
Last name spelled Xagoraris.
Okay,
P32106.
okay, thank you.
Thank you. Sorry about the mix up. This is Aria.
That's not, no problem, Your Honor. So it's February 9th, 2023 at 10 a.m.
Thank you, sir.
Thank you, Your Honor.
Good day.
You too.
We're off the record. That's ridiculous. Let's stop the video. Turn the music back on.
The Ulster Overture, the music of George Philip Tubman on the Ulster River, and Hamburg, Germany, and we heard Philip Pickett in the new London concert. Birthday composer Ermanno Ferrari, that's the Italian composer who won his name in 1876, was probably best known for the secret of Susanna. You can hear its overture and intermezzo next time, and it's studied secret. I mean, just what was Susanna's secret? I'll tell you what that was right after we hear. It's music coming back in the same one. CR639 with the overture and intermezzo from the opera by Emmanuel Ferrari. Today's birthday was one of his dates in 1876. The opera is called Susanna's Secret. And yeah, I know, I promise you, I've done it. Don't tell me. The secret was that that's the secret. The opera. 1909. Speak out that in the garage, they're thinking there, these days, it's still not, that is secret. So Neville Mariner had a mistake. Eric Monroe, Ferrari, and listening to WSCJ.
Morning, Council.
Good morning, Your Honor.
And you're representing whom today?
Your Honor, I'm here on behalf of the plaintiff,
Auto
Pasadena
owners?
Investments LLC.
I'm sorry, Velocity Investments?
Pasadena Investments LLC.
Ah, the wrong one. I had you, okay, I had you the wrong guy. Okay. That's I don't have your opponent as of yet, so I'll put you back in the waiting room.
Thank you, Your Honor.
Counsel, why are you here today?
Good morning. I'm here on Auto Owners versus Rescue Unit Towing and Drake's Collision.
And you're representing whom?
Plaintiff Auto Owners.
Okay. Again, I don't have your opponent as of yet, but we'll get back to you soon, hopefully. Thank you.
All right, thank you.
Waiting room you go. Hello?
Hello,
What is your name?
my name is Lisa. The last name you guys have on the docket is Mitchell.
All right, hold on for a second. We can get started.
Sure.
All right, we are on the record. This is file number 22192513, Pasadena Investment versus Lita Mitchell, excuse me.
Mitchell.
This is a motion to set aside default appearances.
Good morning, Your Honor. Christopher Sossin, spelled S-O-S-O-N-G, 593, appearing on behalf of the plaintiff, Pasadena Investments LLC.
And what is your name, ma'am? Ma'am,
Lisa?
your name is Lisa Mitchell.
My name is Lisa Mitchell.
You are the moving party. Let's hear your motion to set aside the default.
I don't know what any of that means. You want me to explain what happened?
Ma'am, what I want you to do is you filed a motion to set aside default. This is the date and time for hearing on your motion. Why should I set aside the default?
So okay. I don't know exactly what that means, but I'm asking to, I don't agree with their claim for me owing however much they're saying that I owe. For reasons that I described in the letter that I sent to the court.
Ma'am, let me explain your burden here as a moving party. You have to demonstrate under MCR 2.603D two things to set aside default. Number one, that there was good cause for your default. And number two, you have a meritorious defense. Anything you want to tell me on those two subjects, ma'am, you should tell me now.
So I'm guessing that you're asking why I didn't respond.
Well, that's
I
one
called
reason,
this
ma'am.
number.
Why did
I'm
you
sorry.
fail to file an answer to the complaint? You were personally served with summons and complaint on September 26, 2022, and you failed to file an answer. Why is that?
Okay. Okay. I called this number, or I called the number that was provided, and no one ever picked up.
You called what number?
I was
ma'am?
on hold for the number, this number, the 929, the 929-436-2866.
Ma'am, that's a notice for a specific date and time for a Zoom hearing.
Yes, I'm aware. And I called the number on the specific day and time, and no one ever came to the phone. Like today, I didn't hear any of the prompts that I heard today. There was no one answered.
All right, let's hear your meritorious defense. What is your defense to this claim?
So the damages that they are charging me for, to my knowledge, is for debris that was left over in the apartment and the kitchen not being clean, which is untrue. I cleaned the refrigerator and the stove. The floor was swept and mopped. The debris that was left over was a bag of trash, a twin size box spring, and a chair. Those things were said to be moved by the person that was operating the freight elevator. I sent a letter to the court, I think it was sometime in September, detailing all of this. And the person that was working the freight elevator, I don't know what his position is. I just know him by Tony. I don't know his last name. And I've had interactions with him, you know, in the past while I was living there. So when he said, "Don't worry about it, I'll get it," I took his word that he would remove the debris. Okay. Prior to me receiving this letter, I guess I should have checked to make sure that it was done. I don't know. But after that, I was done with it. I left my keys, I left the remote, and I vacated the premises, and I did not go back.
Mr. Sisson, your position.
Thank you, Your Honor. First and foremost, it is plaintiff's position that the defendant has failed to articulate both prongs of a required showing under 2.603D, that being good cause and meritorious defense. The defendant's failed to articulate any reason why she failed to appear at the last scheduled pretrial in this case on November 21st, 2022, at which time the default was entered against the defendant. Second, the defendant did file an answer to the complaint. The defendant, in her answer to the complaint, never disputes owing. The defendant's only contention is the amount that's owing. She doesn't dispute that there was damage that occurred during the course of the tenancy. She does not dispute that there were items left over on conclusion of the tenancy when the defendant moved out. So that's that fact. Those facts are not in dispute. As it relates to this particular motion, the defendant's required to demonstrate a meritorious defense to the claim. And plaintiff submits, Your Honor, that the defendant has not. The defendant's only contention speaks to what the defendant believes the amount of the damage is. The defendant herself does not dispute that there were damages that occurred for which plaintiff has filed this action to seek damages as a result of the tenancy. So it is, again, plaintiff's position respectfully that the defendants failed to meet both prongs of the required showing under MCR 2.603D for the court to set this aside. And respectfully, plaintiff would request that the court deny her motion to set aside the default.
Thank you.
Thank you, Your Honor.
Is there anything else you want to tell the court?
Oh, I do have something else to say. So I was not given back my security deposit, and the legal jargon that y'all are using is confusing to a normal person like me. For someone who's never been in this position, for somebody who doesn't know what these terms mean, it's confusing. So the amount, if I'm supposed to dispute the fact that I have to pay the amount, then yes, I dispute that. I don't believe that I should have to pay that amount. If anything, my security deposit should be enough to cover the doors that were damaged, which I stated in the letter that I sent to the court and to Pasadena, and the cleanup, because really the cleanup would only be like vacuuming and maybe shampooing the carpet unless it's replaced.
All
And
right,
even
thank you.
then, I'm not
Of course,
responsible for that.
The court's prepared to rule in this matter. The requirement under MCR 2.603D is that the defendant who seeks to set aside a regularly entered default must both demonstrate good cause and meritorious defense. For the record, this matter was set for pretrial after the defendant filed an answer disputing the claims made by the plaintiff. The defendant's claim in regard to the good cause is that she was unable, for whatever reason, to log on to the Zoom site. That happens from time to time. Court finds she has demonstrated good cause. I note for the record that no pleading was filed in opposition to the motion to set aside default by the plaintiff. Based upon the representations of the defendant, the court is going to grant the motion to set aside default. What I'm going to do is I'm going to give you guys another pretrial date. I am going to open your written discovery. Your next date with me will be February 9, 2023 at 11 o'clock. There'll be a Zoom pretrial like today. Thank you both for coming in. We are off the record. Ma'am, I would urge you, if you're going to represent yourself, you might seriously consider getting counsel, because you have an absolute right, ma'am, to represent yourself. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. And if you are confused by the quote legal jargon, end of quote, that parties use, that's going to happen in the lawsuit. So let me urge you as strongly as I can to get counsel to represent you. However, if you choose to represent yourself, you have an absolute constitutional right to do that. We will talk to you again February 9th, at
Okay.
11 o'clock. Thank you both for
I have a
coming in.
Thank you, Your Honor.
Ma'am,
Yes.
have a good day.
Will I be able to call this number again on February 9th?
Yes, ma'am. It'll be the same number. It'll be Zoom pretrial like today. Yes, ma'am.
Okay,
We're off the record.
thank you.
Morning, Your Honor.
Good morning. We are on the record. This is case number 22-192503. Auto Owners Insurance versus Drake's Collision. Your appearances.
Morning, Your Honor. Jared and Jessica on behalf of auto owners.
You remember the State Bar of Michigan?
Yes, Your Honor. P77599.
Counsel.
Yeah, good morning, Your Honor. Steve Haney, on behalf of Drake's Collision, P63947.
Okay, first of all, gentlemen, I have a problem here. Looking at my file, it appears that on December 2nd, the court sent out a notice setting this matter for pretrial and opening written discovery. However, it appears that prior to that time, Mr. Haney had unilaterally sent out written requests for discovery. How did that happen, sir?
I didn't send out any written request for discovery
I'm sorry.
unilaterally. I wouldn't do that.
Did you do it by stipulation of the parties?
I believe the plaintiff sent out discovery to me. I don't believe I sent out discovery to the
I thought
plaintiff.
there was.
Am I right, Jared, or no?
I'm looking at plaintiff's answers to defendant's request for admissions.
Yeah, I believe we have several files together, Your Honor, and we had been basically exchanging discovery back and forth on all these files. So I believe I sent some to Mr. Haney. He responded to those and I responded to his, vice versa. We did not enter in a stipulated order per se, but we've had a mutual understanding that we're complying with discovery and it's been a smooth process so far.
Well, I got a problem here.
Okay.
If you guys were in the circuit court, good for you. But that's not where we are. In the district court, discovery comes one of two ways, gentlemen. Stipulation of the parties or order of the court. I would be the court. I didn't enter an order until December 2nd, and then that was only for written discovery. So if you guys are going to conduct discovery by stipulation, I have no objection. But I need a stipulated order from you gentlemen to that effect.
Understood, Your Honor.
Your Honor, it was my recollection that on the prior occasion that court did order or a limited period of discovery and that we've complied with that unless I have that.
You're not hearing, Mr. Haney. If I send out an order on December the 2nd, opening your written discovery, how is it that the defendant sent out requests for admissions, requests for production of documents dated November 2nd?
Your Honor, I will check into that, but
Indeed.
I will check into that, Your Honor. We have about 15 files together, and if I sent him anything, I would gather it was in response to something he sent me, because I've not been triggering or initiating any discovery in any of these files.
Well, that's what the file here seems to suggest, Mr. Haney, because there's not.
Fair enough, Your Honor. No, I respect that, Your Honor. Thank you.
Apparently you gentlemen have, is there a deposition scheduled for tomorrow?
Not to my understanding.
Not that I,
That's interesting, because I'm looking at a notice of deposition of representative of plaintiff Allstate for February the 13th, January 13th at 2 o'clock, signed by one Steve Haney, dated November 2nd.
Your Honor, I'll check into this, Your Honor. If it happened, it was by my staff, which is my responsibility. I understand that. As noted, we literally have 15 other files together, and this is likely was part of some mass responsive effort and discovery effort on behalf of my office. So I would, I'm not disputing what you have, Your Honor. I understand the court's directive and the court's position on this. No misunderstanding from me, Your Honor.
All right, gentlemen, here's what we're going to do. If you're going to do anything beside written discovery, I'm going to have a stipulated order to that effect. Because if we get to the point where we can't resolve the file, we end up going to trial, then somebody's going to say, Judge, I didn't agree to that deposition. All right,
understood.
here's what we're going to do. I'm going to see you gentlemen on February the 9th at 11 o'clock. I will continue the written discovery that I opened on December 2nd. Is there anything else we can accomplish today?
In Your Honor, so you said February 9th.
February 9th, it's a Thursday like today, at 11 o'clock like today. It's on Zoom like today.
Your Honor, I am taking a flight and I'm landing in Seattle at 10:45 a.m. Is it possible to have a different date or?
Well, we have to. I don't think you can do it on the phone, on the plane. How about we do it a week later on that will be the 16th.
That would be great, Your Honor, if the court
Mr.
could
Haney?
accommodate me.
I'll make that date work. Thank you.
February 16th at 11 o'clock, your written discovery will remain open. You gentlemen need to decide what you have going to do about that deposition that Mr. Haney noticed for tomorrow. If you're going to take it, I need to see a stipulated order for the deposition. Otherwise, we'll talk to you again February 16 at 11 o'clock. Is there anything else we can accomplish today?
I think that's it, Your Honor. Thank you.
No, thank you, Your Honor.
Okay, let's be
Thank you.
safe out there. Thanks for coming in.
Thank you.
You're
Thank
welcome.
you. Steve, I'll give you a call.
Hello,
Yes,
what is your name?
my name is Lawrence Gardner, sir.
Let's get started. You may let Mr. Johnson in here.
Pardon me?
Let's get Mr. Johnson in here. We can get started on your file.
Okay, the reason why I'm calling. is
No, wait.
Zoom call.
All right. We are on the record. This is case number 22-191-559. Velocity Investments versus Lawrence Gardner. Date and time for what appears to be our first pretrial, your appearances.
Good morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
And what is your name, sir?
My name is Lawrence Gardner.
Mr. Gardner, is it your intention to represent yourself in this matter?
Yeah,
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind Mr. Johnson will bind you. Do you understand that?
yes, sir.
All right, well, we're on this file, gentlemen. The court opened your written discovery. Have we gotten started on that?
Your Honor, happy to report that a motion for entry of consent judgment should be coming to your desk in short order. Mr. Gardner signed it, the consent judgment for the full amount with a, I think a 90-day forbearance on any collection activity. And that's, yeah, it will be, this matter will be resolved in short order.
Mr. Gardner, you signed that consent and returned it to Mr. Johnson's office?
Yeah, the gentleman that I talked to was Joe Harris.
All right. Do you have that ready to send to me, Mr. Johnson, or you think it's coming soon?
It was mailed a couple days ago. I can email you a copy if you'd like.
If it was mailed, it'll catch up.
Okay.
What I'll do is I'll put this on a February 9th, the return date. And by that time, you each should have received your copy of the consent judgment. Then there'll be no need for you to come in. So just to keep the matter safe, February 9th at 11 o'clock, but I don't expect to have to see you at that time. We'll send out an order that today. Thank you, gentlemen.
All right.
Okay,
Thank you, Your Honor.
Okay,
Be safe.
okay, thank you, sir. Okay.
Morning, Your Honor.
Mr. Cox, good morning. What brings you here today?
Judge, I had a file scheduled for a pretrial. We submitted a consent judgment on it. I just don't have an entered copy back, so I just wanted to make sure the court had it.
Okay. It's still listed here as a pretrial. How long ago did you submit the consent judgment?
It looks like it was submitted, or at least out of our office, on like December the 6th.
Yeah, because I don't have the file, which suggests to me that it has been already caught up with. What I'll do is I'll catch up with the file, and I'll make sure that your consent judgment gets entered.
Okay.
Okay?
Thank you very much, Your Honor.
Thanks, Mr. Cox.
Yeah, it was good to see you, Judge.
Good to see you. Have a great day. We're off the record.